Good afternoon, dear participants. I am very happy to welcome you on this joint webinar organized by the Ukrainian Arbitration Association jointly with ICC Ukraine on a very important topic now for Ukraine, and that is from freezing to sizing, legislative initiatives and hurdles in the US, European Union, UK and Canada. And my name is Elena Perpolinska. I'm president of the Ukrainian Arbitration Association, vice president and head of Arbitration Commission of ICC Ukraine. And today I have an honor to moderate a discussion together with my colleague, Alexey Maslov, member of the board of the Ukrainian Arbitration Association, member of Arbitration Commission of ICC Ukraine and counsel at Avellum. And together we will moderate the discussion of two speakers, both from Ukraine, but now living in other countries. So first, Tatiana Nesterchuk, barrister and arbitrator of Fountain Court Chambers in the UK, and Anton Moiseyenko, lecturer in law, Australian National University. Both our speakers have a very deep knowledge and long history of the interest in the topic. So Tatiana is an author of the draft law on this topic in the UK. Anton is an author of a book related to on corruption-related sanctions, and has recently also published an article, Sovereign Immunity Sanctions and Confiscations, the case of central bank assets. As noted, we will discuss this topic from the point of view of four jurisdictions, US, European Union, the UK and Canada. And we would like to divide our discussion into broader topics. So one related to Russian sovereign assets, and the other one related to the assets of sanctioned Russian entities and individuals. And now I will pass the floor to Alexey to start a discussion of our first topic, please.
Yes, thank you very much, Helen, and nice to see everybody today. So yeah, we will start with sovereign assets belonging to the Russian state or the entities of the Russian state. I guess the assets that are most commonly discussed and heard of in the media are the assets of the Russian Central Bank, which were reportedly frozen in many jurisdictions. Reports vary as to the exact amount of those funds, with estimates going up to 350 billion of US dollars. However, it is not clear how the frozen assets are actually monitored and where they actually stored. But nevertheless, it is of course quite a big amount, and we all understand and remember that under international law, Russia is due to pay reparations for its violations of international law against Ukraine. So an immediate reaction from nearly anyone would be to say, well, why not use these assets to pay Ukraine the reparations on behalf of Russia if Russia refuses to do so. But here, with respect to sovereign assets, the major legal obstacle is, of course, the rules of customary international law on sovereign immunities, which are enshrined in legislation of many countries which hold the assets of Russian Central Bank. So I would like to start the discussion with the description of general framework, how the sovereign immunities work now in the modern context, whether any exceptions that can be used in order to actually go from freezing the assets of Russian Central Bank to seizing them. I would like to ask Anton to start, if that would be comfortable for you, given your great article, which I enjoyed reading and highly recommend to everyone to read about the assets of Russian Central Bank.
Thank you so much, Elena and Alexey, for having me here today. And it's a pleasure to appear here alongside Tatiana. As you mentioned, the topic could not be more important. And I think Many people have jokingly referred to the $300 billion question. I think partly it's the amount of money that is involved that makes it of profound importance, both for the reconstruction of Ukraine, but also for the funding of the ongoing needs of Ukraine's defense, and indeed keeping the lights on and ensuring that the infrastructure keeps working. It's also, I think, of great importance potentially in terms of setting a precedent for the future, in terms of the consequences that states might face when they engage in aggressive war. But I suppose we might come back to some of those broader political aspects of the question a bit later on. So, diving straight into the customary international law of sovereign immunity, that, as you've mentioned, is one of the key hurdles for states, I think what makes the issue so particularly difficult, and for now, for over a year, it's been really intractable, is the fact that we don't really know we're not quite sure, we don't know quite well what international law of sovereign immunity actually entails. It's a bit rough around the edges. So we know, for example, that if a state enabled its own citizens to bring claims against another state in its domestic courts, get judgments against the other states in domestic courts, and then enforce those judgments against, for example, the assets of a central bank, that would likely be in breach of sovereign immunities. But there are at least two areas of profound uncertainty. One question is whether sovereign immunities apply in equal measure to actions by domestic courts, as well as to the actions by the executive, that's to say the government, and by the legislature. What I mean by that is that, as you've alluded to at the very beginning, most states in the world enshrine sovereign immunities in their domestic legislation. And there are also some sources at the international level that tell us what sovereign immunities entail. For example, the work of the International Law Commission that then led to the adoption of the UN Convention on State Immunity, which is not enforced, but nonetheless is taken to reflect customary international law by and large. So the challenge there is that legislation and the international sources speak exclusively of the courts, the actions of courts. And on the one hand, if you look at that, you might ask yourself, okay, well, what about confiscatory action that doesn't involve the courts? What if countries that froze Russian assets chose to do that in a manner that does not involve the courts? Would the answer have to be different than if the courts were involved? So that's one question, and we might go into a bit of detail there if you want as to the arguments pro and contra, but this is one of the areas with this great and vigorous debate at the moment. And the other area is in relation to the application of countermeasures under international law. So most of the time, if you have an obligation under international law, you can temporarily deviate from the performance of that obligation in response to another state's breach of international law. There are a range of requirements that attach to that right to deviate from your international obligations, but basically they all boil down to the countermeasures not being punitive. And so one important issue there is whether or not the law of countermeasures can serve as it were, a justification for temporarily deviating from the observance of Russian state immunity and going after those assets. Now, before I stop there, I think one other issue that I would just like to highlight is that the manner that international law plays out in the domestic legal systems of states concerned can also be somewhat different. So in some countries, it is theoretically possible to legislate in breach of international law, but it's just not an attractive proposition for a variety of reasons. And in other countries, for example, Germany, international law is a hard limit. Under the constitution of those states, you need to act, even domestically, in a manner that is compatible with international law, and that further raises the stakes and makes sure that the issues that I've just outlined are really key, not just in terms of policy and international law, but also in the context of the domestic law of these states.
Yeah, thank you, Anton. I would like first to discuss in more detail this distinction between executive and judicial confiscation, which is a really interesting idea, but somewhat, I would say, a paradox for me, because generally, I think that the idea is that the more courts are involved, the more there is a rule of law and the more scrutinized any process is. But here it turns out that it is the opposite. The less courts are involved, the more the process could be viewed as complying with international law. Don't you find that don't you find that strange?
I do. I think Tatiana wanted to jump in. I assume she will find it strange too.
If I may jump in, I mean, in fact, the
Yeah.
paradox, I believe Anton at a recent event we've been to, Anton himself said for me, it's a paradox. I think it arises, this paradox or apparent paradox, arises from a misunderstanding of what sovereign immunity is. Now, the sovereign immunity is, in fact, speaking as a practitioner, is a defense raised by sovereign states against a jurisdiction, against a court of another sovereign state assuming jurisdiction over that state. It is a defense, right? The principle of sovereign immunity arises from the principle of sovereign equality of the states. Because each state is equal, each state is sovereign, each will not be subject to the jurisdiction of another state's court unless they so choose. We mustn't forget that there are plenty of exceptions to sovereign immunity. One of those exceptions, which is enshrined in our State Immunity Act in the UK, and a similar exception exists in the US at least, is its tort exception, of course, which is that where one state commits acts which lead to damage on the territory of another state, well, then that state which commits the damage is no longer immune from the jurisdiction of the courts of that state. So there are plenty of exceptions. Another exception, of course, is submission. So there are plenty of states that come and submit to the jurisdiction of other courts. Another exception, submission via an international treaty. So courts can be subject to international court jurisdiction. So it is not the case that there is this general principle existing somewhere in customary law that all states are immune from, all state assets are effectively immune from actions by other states. It's just simply not the case. So there is a general principle, and this is why we're talking about judicial acts. When you look at all statutes are talking about jurisdiction, immunity from jurisdiction of the courts. So it arises from the fundamental principle what sovereign immunity means. So it derives, and this is, you can find this in the judgment on jurisdictional immunity by the ICJ, International Court of Justice, Germany and Italy. That judgment explained that the principle of sovereign immunity derives from the principle of sovereign equality of the states. And it also must be viewed together with the principle that each state possesses sovereignty around its borders. When you have a state such as Russia, which fundamentally disregards the sovereignty of another state, Ukraine, I think it is clear at this stage that on any level, whilst the jurisdiction immunity remains, on every other level, there is no longer the requirement that we, the rest of the world, or at least Ukraine, respect the sovereignty of Russia. There's been a lot of discussion as to whether there is this customary principle of international law that the assets of another sovereign state, especially state assets of another sovereign state, are inviolable. Now, we know full well that in times of war, so Second World War is the closest example, a state which is at war with another state is absolutely free to confiscate all the assets of that state that they have. So the question here is whether third-party states, so states who are not party to the war between Russia and Ukraine, can assist Ukraine by confiscating Russian state assets. So that is the question. And a lot of people say, well, surely Russia's sovereign immunity is a barrier to that confiscation. My answer is no, because state versus state action. What is executive action? First of all, we're not talking about an action of an executive just deciding to confiscate. What we're talking about is legislation mandating the executive to do this. So we're talking about state-to-state action, legislative action, first of all. Now, each state is sovereign and each state is free to do whatever it wishes to do in terms of its laws. And so any state can decide as a political action to confiscate another state's assets. Now, they can use any sort of reasoning for that. And one of the reasons might well be, well, we require Russia to pay reparations. So that could be, may well be a reason. America, I think, is going down the countermeasures route, and I'm sure Anton will have more to say about that. So there are many, and I think UK, for many reasons, will not be able to go down that route because the way that Russian state assets have been frozen has not been justified as a countermeasure. There's not a sanction, effectively. So, and again, they have not been frozen. All that's happened to Russian state assets is that they cannot in any way be dealt with. And so in that sense, they're frozen. But there's been no freezing. There's just been legislation, or rather secondary legislation, which prohibits anyone from dealing with those assets. And so what we're talking about is political action. And when you look at it at that level, sovereign versus sovereign level, then there is no paradox. We're not saying that the protection of the courts will not be permitted. So, for example, in English law, any executive action is subject to the judicial review of the courts. Now, nobody is going to exclude that judicial review. So a court would still be supervising the executive, making sure the executive acts within the scope of the powers granted to it by Parliament. So that level of review by court will remain. But of course, Russia will be no part of that review because the respondent to any of that sort of review will be the executive taking the action against Russian state assets. And so the courts will not be adjudicating on rights of Russia. It will simply be adjudicating on what the executive minister to whom powers have been mandated by Parliament, whether that minister had performed his powers in accordance with the English laws. And it is the Parliament that makes the English laws. And so this is where I think we're getting lost, because we're not just talking about a minister deciding, or a president in the US deciding to do it. We're talking about an executive doing it in accordance with the English law or the US law, in Canada in accordance with Canadian law, as mandated by sovereign Parliament.
Yeah, thank you very much, Tatiana. That was great clarification, and you alluded to a lot of interesting things I would like to discuss a little bit further. I would start with your statement that it is absolutely proper for a state which is in a war with another state to confiscate that state's assets, and you referred to the examples of the confiscations during the Second World War. So what I was interested in hearing is, are there any more recent examples of that practice? And I refer to the situation during the 2003 war between the United States and Iraq, in the wake of which, as far as I understand, the United States used the president's power under the Emergency Economic Powers Act to confiscate the assets of Iraq's central bank. So my question would be, what's your position on that particular instance of confiscation, whether it was in accordance with customary international law, whether it reinforced the principle that a state at war may confiscate the assets of another state with which it is at war? And the second question is whether the same powers can be used in a situation where one state wages aggressive war against another. So in other words, whether the United States could use the powers of the president under this act to confiscate Russian assets.
I will quickly answer, and I'm sure Anton will have more to say. So in terms of the US powers, my understanding is that what they have done is not quite what's being proposed to be done here against Russian state assets. So what they have said is that they're not in fact confiscating Iraq state assets. What they're saying is that the Taliban regime, effectively, who runs Iraq, is not an emanation of the Iraq state that they recognize. So effectively, they're not confiscating assets that belong to Iraq. They are saving those assets for the benefit of the Iraqi people. That's how they explain it. And so that is a slightly different example. So it is not an example of confiscation, it is simply an example of non-recognition of a state or people who run the state at that stage. They have done a really interesting thing, because from what I understand, 50% of the central bank assets have been transferred to a special fund, and I don't know what happened to those monies. I think they're still sitting there. And another 50%, they said, could be used by way of compensation of claims for the terrorist attacks by the Taliban. Now, that is a very novel use, and I would say that that, in fact, is an example of confiscation of state assets for the purpose of satisfying judgments for loss arising out of acts by the Taliban, because they don't recognize is part of or head of the Iraqi state. So by a terrorist organization, effectively, against US and US citizens and companies. So I would be interested to see how that develops, because the claims are currently, I think they're just about coming to the stage of enforcement now. So I would certainly be interested in seeing how the US court decides to deal with those assets, and whether US courts will permit the use of those assets to satisfy the claims arising out of 9/11. And I think we will be able to draw a lot of parallels with the current situation between Ukraine and Russia.
Thank you, Tatiana. Anton, would you like to add anything on this point?
Yeah, look, just a couple of things. I suppose maybe just zooming out a little, one comment that I would make is on the general use and prominence of international law in the discussion so far. And I think what we've seen is that a lot of governments have publicly been ambivalent as to what exactly they want to do with Russian assets. And, the fact is there's no risk-free option there. You either hand them over back to Russia at some point down the line, or you use them for Ukraine's reconstruction or to support Ukraine, or you keep them frozen indefinitely, in which case you run into pretty much all the same legal issues that you do if you simply hand over those assets to Ukraine. So there's a pretty interesting dilemma there with sort of three different roads that states can take. And so far, what some governments have been indicating in a sort of public and semi-public manner is to say, we'd love to support Ukraine and transfer the frozen assets to Ukraine, but international law doesn't allow us to do so. And this is where I think we run into this obvious question of, really? Does international law really not allow you to do that? Or is that just a convenient way to maybe postpone the consideration of those issues until some later point? And this is where I think when we actually look at international law, there are difficult issues there. There are complicated questions, but they're pretty finely balanced. And there are a couple of perfectly plausible arguments under international law that states can, in fact, in good conscience, transfer those assets to Ukraine. And as I said, I think there are two major ways of doing that. The first one is to look at the limits of sovereign immunities and whether or not they cover executive/legislative action. And the other question is the role of countermeasures. And, whichever way you go, there are some issues there, and there's a need to be very serious about considering them. But I think that it would be far too simplistic to say that there is a barrier on transferring those assets to Ukraine. So I think it's in this context that we're sort of having that discussion. Now, as relates to immunities and the executive versus judicial debate, I think it's interesting to note that international law already has a legal regime that protects certain state property from all manner of interferences. There's already a legal regime under which it is crystal clear that the executive, the legislature, no one can take any action that interferes with that property, and that is the property of diplomatic missions under the Vienna Convention on Diplomatic Relations. That property is inviolable. So there's already a distinct regime under international law that covers some state property. And so to say that central bank property is likewise protected from executive and legislative encroachments alike would be effectively to say that it is inviolable. It benefits from that extended range of protections that so far has only been recognized in relation to the property of diplomatic missions. Maybe that's the correct view under international law, but it is at least questionable. So I think lots of uncertainty there. And if we look at countermeasures, I think the position is much clearer there. And I think the argument that those assets can be liable to confiscation is really much, much stronger there. In fact, I don't see any particularly cogent objections against that line of argument. Now, in relation to international precedent so far, I think if we're being perfectly honest, there's nothing that is exactly like that. There are precedents that are kind of similar in some way, shape, or form, in that you have the property of central banks that is frozen and then occasionally seized. And in some instances, you see states just doing that. For example, the United States measures against the property of Iranian central bank and Iranian companies. They did it. They went very far indeed. They explicitly authorized their courts to satisfy claims by US citizens against Iran. So things have been done in the past that are kind of on the same plane in terms of what's happened, but the analogies are always imperfect. And one thing that I would say there is that we don't have direct precedent for coordinated multilateral confiscation of sovereign property of another state, just because for practical reasons, it's a wholly unique situation. All those countries rightly value their position as attractive places to do business. When would the issue of potential confiscation of another state's central bank assets arise? It can only arise in the situation of truly egregious breaches of international law that have been widely internationally condemned, where you have the amount of damages that is inflicted on the country that has been the victim of aggression that are roughly commensurate with the amounts of property being frozen. And so we simply haven't seen anything of that magnitude and any situation that would really give rise to those considerations in quite the same way since the Second World War. And so I think that really accounts for that lack of precedent. It's not some insurmountable legal obstacle. It's simply that for practical reasons, that question has not arisen. And that's why we have this apparent lack of precedent.
Thank you, Anton. So as Tatiana said, with respect to executive compensation, we should not expect, and I guess, Anton, your very illustrative description of the scale of this situation, how it is unprecedented compared to everything that happened before. So we should not expect to see an executive branch, either in the United States or United Kingdom or in any other country, just one day declaring, okay, we have decided we seize all Russian assets and transfer them to Ukraine, either directly or through some fund. So in any event, we should expect that this issue would be dealt somehow on the legislative level of these states, or perhaps even through an international treaty among these states and Ukraine, for instance. And correct me if I'm wrong, but I understand that current state of progress on these legislative initiatives could be described as central governments are quite reluctant. They just wait and see what happens. They do not move actively towards introducing any legislative acts that would allow confiscation. However, in different states, including the United Kingdom and the United States, there are some members of parliament who would like their state to act quicker and who introduce certain bills, certain proposals to allow their government, either through executive action or otherwise, to confiscate Russian assets. So my question is first whether this characterization is correct, that governments are mostly reluctant, but some members of parliament are more eager? And second, whether there are any such bills that you would like to briefly describe to us so that we understand what we should expect from different jurisdictions in our focus today.
I'm happy to start. So
Yeah.
In terms of the position in the UK, at the moment, we have sort of two initiatives, maybe several initiatives. First of all, we have the Private Members Bill by Chris Bryant, which I have drafted, confiscation of Russian state assets in support of Ukraine. Now, that bill, as a private members bill, effectively, it would be, without the support of government, it would be very difficult for that bill to be passed. For two practical reasons. The first practical reason is that without the governmental support, there will be no requirement by the government of the MPs, members of parliament within its party, to vote in a particular way. And therefore, members would be free to vote how they wish, and so you'll have to get support within parliament for that bill to pass. Now, that is not actually a big issue because there's already a huge multi-party support for this initiative. And in fact, 60 members of parliament have signed a letter to the Prime Minister on the day of the anniversary of the war, the full-scale invasion, on 24th February 2023. 60 MPs signed a letter to Prime Minister requesting that this bill goes through. But there is another practical reason. So the bill had not been allowed to progress through Parliament. So in order for the bill to be voted on, it's got to progress through each stage in Parliament. And the first stage is for the bill to go into a committee and to be debated, negotiated, updated, improved. Now, and it is up to the governing party who are in charge of parliamentary process to allow that to happen. The bill was due for the second reading, following which it would have gone into a committee on 24th of February 2023. And what happened on that day is that we were told that there isn't enough parliamentary time to have a second reading of the bill. So the bill was put to the bottom of the agenda, and we were told we simply ran out of time. And what also happened is that the time for the second reading was rescheduled all the way to November 2023. So this is, in practice, this is what the government can do to stop the bill from progressing. Is this a sign that the UK government is not supportive of Ukraine? I say no. What it was a sign of is that the UK government simply had not started thinking about the issue. And I know that now they are thinking about the issue. So the bill has done a very important first job, which is to present the government with an idea of what might this legislation look like, and with arguments, legal arguments to support it. So that, for that reason, the bill has served its purpose. And what happened afterwards is, first of all, on I believe on 19th of June, the government had amended by secondary legislation. So secondary legislation is effectively legislation that can be done by ministers, kind of executive type legislation, which doesn't need to go through Parliament. And the government does have powers under primary legislation to issue these secondary legislation. So all the sanctions, for instance, they're all done by secondary legislation. So because it's got to be done quickly. And it can't go through the whole parliamentary process. And what the government has done on 19th of June is that it's amended the sanctions regulations to say that the assets which have been frozen will remain frozen until Russia pays reparations. There is an issue though. The state assets have not in fact been frozen under the sanctions regime. So state assets have simply been blocked. I say block, you can use whatever word you want, but effectively you simply cannot make any transactions in respect to those state assets. They've been blocked where they are, but they're not subject to the sanctions regime. And so, strictly speaking, what the government has done here will not apply to state assets. And it is in fact questionable because at the moment there is no proposal to confiscate assets of individuals which have been frozen. So it is a little strange that this is how they've chosen to do it. But the thought was behind it was actually that the state assets will also remain frozen until compensation is paid. So, and I believe this is what will happen. So there is now a clear guidance, I would say, from the UK Parliament, from UK government, that they will continue to keep the assets frozen until reparations are paid. Now, what happens if no reparations are paid? Well, as Anton said, $300 billion question. My argument is that you can go further and you can say we will use those assets to satisfy, to discharge Russia's obligation to pay reparations, and we will set off as against the assets that have been transferred to Ukraine or to any fund. We will set off against, we'll set off the sums paid against Russia's obligation under international law to pay reparations. Whether that will happen is another question. But so that's the one thing that has been done by the UK government. And the second very interesting development is that on 27th of June, so this is all around the Rebuild Ukraine conference. So 19th of June was literally 2 days before, and then 27th of June, which is about a week after the conference, there was a big debate in UK Parliament about confiscation of Russian state assets, and Chris Bryant, who has supported, who of course has the bill, and many other MPs who support the initiative, have resolved by majority, so there's a majority panel resolved to mandate the government to present a bill before the House within 90 days to allow frozen Russian state assets held in the UK to be repurposed for Ukraine's recovery. And so I think because of that, we would be expecting to see something. And I know privately that certainly behind the scenes, a lot of work is going on to work out how this could happen. And UK might well be the second state after Canada to introduce this kind of legislation. So the work here continues, and I would say we should be expecting to see something within the next 3 months. Then there's Canada, which of course has passed SEMA very early on in June. The senator behind the SEMA, which is the I think it's called Special Economic Measures Act. So the senator behind this amendment, Senator Ratna Omivar, has been working with the MPs in the UK who are behind the Chris Bryant's bill. And she, in fact, is Iranian, and she's been working on this issue from Iran's position. And you might not know, but there is a very interesting case issued by Iran against Canada in the International Court of Justice, complaining that Canada has suspended or violated Iran's sovereign immunity because it designated Iran as a terrorist state effectively, and allowed lots of judgments to be, well, several judgments to be enforced against Iranian state assets. So the background to the bill is Iran, but actually was passed just as the war in Ukraine started, and it could be used. It's not specific to Russia and Ukraine, it is general, so it could be used in the situation. So certainly this is something they want. So this is kind of another example of executive-led action. So with that act mandates the governing council to seize Russian state assets. Now, there is a problem for Canada. Well, not a problem. That practically there aren't many Russian state assets in Canada. As I understand, there's only about 160 Canadian dollars worth of state assets. Everything had been moved to Belgium just before the war. So this is really interesting, that pretty much everything was moved to Belgium. That's why Euroclear has is holding so many funds. The problem with that legislation is that after the initial confiscatory order by the executive, the issue then has to go through the court process. And because the court will then have to rule not just on the validity of executive action, the sort of judicial review type procedure that you see in the UK, but the court also has a mandate to decide whether or not the seizure should take place. And so effectively, the court will be ruling on the sovereign position of the Russian Federation. And for that reason, the legislation doesn't quite work, and it requires to be amended. And as I understand it, the amendments, the technical amendments that are scheduled to be tabled in September and passed then. And so what we can expect is Canada to perhaps be the first state to actually confiscate, so to go from freezing to seizing. So we could expect Canada to be the first state to confiscate. There's not much in it, there's only a couple of $100, as I said, but we might well see the very first seizure of state assets rather than oligarchs' assets. The country that's most important is, of course, Belgium, the EU, which is where the majority of funds are held. What they have done, and I mean, I haven't seen, maybe Anton has, I haven't seen a lot of reasoning coming from the EU. They've had this working group looking at the issue for a very long time, and they've ended up with a very strange position that they said what we can confiscate is interest, but we can't confiscate the principal. That makes very little sense to me, because the justification for confiscating interest rather than principal is that interest is simply a right under a contract with the bank. And so they say, well, we can take that, but we can't take the principal. And the argument that I raised is that, well, hang on a minute, when you look at the assets, the Russian state assets that are held, a lot of them are rights under bonds, under sovereign bonds. And those are also contractual rights to payment. And in fact, when you even cash in bank, you know, that in itself is a contractual right to payment. It is not a property. It is not kind of a piece of gold that's yours. It is a contractual right to payment. And so to me, it just makes no sense that you distinguish between one contractual right to payment and another contractual right to payment. So on what basis they've satisfied themselves that interest can be confiscated but not principal, I do not know. But that's where they ended up, and I understand from a recent roundtable item that there might be some sort of justification in international law, of which I'm not aware. But in terms of private law rights, that makes no sense. And in the US, there is again a sort of the equivalent of a private member's bill, so a senator's bill that's been introduced in Senate, which is possibly the kind of, I think the title that is Rebuilding Economic Prosperity and Opportunity for Ukrainians Act, or REPO for Ukrainians Act. So that is probably the most developed type of thinking. So if I was writing my act now, my bill now, I would probably provide, rather than for a trust, which is what we have done, because at the time in winter, nobody really was thinking about some sort of global international mechanism and fund. I think now everyone is probably agreed that there will have to be some sort of international fund located centrally, probably in Europe, to which everyone would have to sign up. And so I think, and that's what you see in America now, this idea of creating a special fund, a common Ukraine fund, from which reparations would have to be paid. And the reason for that is, of course, another development that took place on the Council of Europe stage, on the international stage, which is the establishment of the Register of Damages in The Hague.
Yeah.
So having established a register and a mechanism for registering claims, the only logical extension is that there will then be a mechanism of adjudicating on those claims and a mechanism of paying those claims. And so we cannot get away from the need for some sort of fund. So I think what we can say now is that what we will see, we will not see money being necessarily handed over to Ukraine, but I think we can expect to see the country start at least discussing the idea of a global international fund for reparations to Ukraine. And I think the basis for that fund might well be some sort of international treaty between the countries that hold the majority of state assets. And I think once you have that treaty, that's what would make it easier for the states to decide to go from freezing to seizing, because they will have support of others behind them.
Yeah, I thank you very much, Stan. And I would say that it is already a very positive development that, as you say, compared to to how the bills looked back then and how do they look now, it's a leap of progress, I would say, because I have also read the repo bill introduced into the US Senate, and I was surprised pleasantly with the quality and the level of thinking that was behind this bill, including the fact that it corresponded to the Ukraine's idea of compensation, three-level compensation mechanism with the register, fund, and the adjudicative body distributing. Thank you very much. And I guess we'll now jump into the second part of our webinar, because we have spent quite a lot of time on sovereign assets. So Anton, unless you have some final short remarks on sovereign assets, I would pass the floor to Olena, and we'll discuss another very interesting topic concerning the private wealth of sanctioned Russian persons and entities.
Look, I have a couple of remarks that sort of blend into the private assets side of things, but also trace the, I suppose, evolution of thinking about this whole problem of Russian assets, public and private. But the only quick comment I would make that pertains specifically to the sovereign assets side of the equation is around countermeasures. And I just wanted to raise that very quickly, because under international law, as I mentioned, generally speaking, states are entitled to deviate from the observance of their obligations vis-a-vis another state in response to that state's own breach. It's a pretty common sense notion that if you're an outlaw state, effectively, that wages aggressive war, you can't be expecting other states to respect your sovereign immunities. And therefore, the question that might raise is, what on earth could be the problem there? Why is that a subject for discussion at all? And I think the biggest problem so far has been this notion of reversibility of countermeasures. Lots of people would point to countermeasures being by default and by their nature temporary and reversible. So you deviate from the performance of your obligations for a bit, and then you scale it all back and return back to the status quo ante once that other state is back to compliance with international law. Now, there are a couple of problems with that view, and some people would cling to that view as justification of saying that state-owned assets can never be confiscated because confiscation is not temporary, it's not reversible. There are two main issues with that line of argument. The first one is that the requirement for countermeasures to be reversible is not absolute, and the International Law Commission is clear that countermeasures need to be reversible insofar as possible, and it depends on the nature of the situation whether that is possible or not. The basic underlying principle is simply that countermeasures must not be punitive. And that leads to the second problem with that argument, which is that once Russia complies with all of its obligations under international law, no one would have any objection to reinstating all that sovereign wealth. Russia takes its troops out of Ukraine, provides full reparation to Ukraine in the amount of, however many hundreds of billions of dollars that is, and absolutely can have its sovereign wealth back. So there's really I think there's no cogent argument against countermeasures based on that precept of reversibility, but it's something that has been quite prominent in expert commentary so far.
Thank you, Anton. And indeed, as I understand, this repo draft bill also supports this second concept of countermeasures. And actually, according to the draft, Russia is invited first to pay voluntarily, and all this confiscated money could be returned back to Russia in case Russia fulfills those conditions, like including the reparation of damages caused to Ukraine and its citizens and entities. Thank you very much for this very interesting block of and your discussion. Actually, we have already started discussing some issues related to private individuals, but just a background. According to recent estimates, there are around 60 billion of frozen private assets of Russian oligarchs and politicians. And unlike the sovereign assets, they are assets most of, first of all, of course, central banks. Those private assets are held by hundreds of sanctioned individuals and entities. And also they do not enjoy the sovereign immunity protection. They do enjoy the protection of private property, which does exist in many legal systems. And to confiscate those assets is also a challenge. So, however, in the recent months, we have seen that some states decided to confiscate the assets of such individuals and transfer them to Ukraine. So Canada moved against the assets of Roman Abramovich, US authorities against the assets of Malofeev. So let's discuss a bit the grounds and the main obstacles of such confiscations. Would like to start?
Look, I'm happy to start on that. And I suppose just in terms of the history and the timeline of how things developed, private assets have been the first point of focus for the nations that froze Russian or Russia-related property. And it's actually quite interesting because what we're seeing is the full-scale invasion began on the 24th of February. Within a matter of 2 days, Russian sovereign assets were frozen, but also so were the assets of a number of individuals allegedly affiliated with the Russian regime. And then very quickly, task forces were stood up at the domestic and international level. For example, in the US, the Klepto Capture Task Force. The EU has got its own Freeze and Seize Task Force, which is really the brain center behind the ideas that we've been discussing in relation to both private and state assets. And there is the Repo Task Force internationally that coordinates the work of those domestic task forces. Now, what did they say was the mandate of all those task forces? 2 things. First of all, the effective enforcement of sanctions, so identifying assets that need to be frozen. And this is a major issue in relation to private assets, because what are sanctions? Sanctions are basically a list of names. Anton is sanctioned, Anton's assets need to be frozen. Now, it's important to ensure that banks look at that list and actually look for Anton's assets, and especially look for those assets if they're hidden behind nominee owners, behind corporate structures. Does that happen? Does that happen effectively? Who oversees that? So this is one part of the remit of those task forces. And then the second part is confiscation. And all of those task forces were pretty clear that they will go after the wealth that can be confiscated. But the default position is that private wealth can be confiscated if it is derived from crime. So here we're talking about the ordinary sort of run-of-the-mill application of proceeds of crime laws. If your property comes from corruption, it can be liable to confiscation, but not otherwise. And this is basically the starting parameters. We've got all those assets that are frozen out there, those 60 billion, and maybe some part of that potentially derives from crime, but that's got to be proven in a court of law in order to confiscate that property. And so with time, it became clear that there was a political appetite to do more and to try to facilitate the confiscation of assets owned by private individuals. And there were, I think, 3 ways in which states have gone about that. First, the least intrusive way would be to introduce minor tweaks to their proceeds of crime legislation. For example, the Biden administration mooted a proposal for enabling the confiscation of property acquired in connection with unlawful activity rather than as a result of unlawful activity. So very minor tweaks around the edges. The second avenue that states have been pursuing is confiscating property that is involved in sanctions evasion. And the idea here is that your property is frozen, you're not allowed to deal with it. Now, what happens if, in spite of that prohibition, you choose to deal with that property? One answer is, well, maybe we should confiscate that property. The United States has got a legal framework that enables precisely that. And the European Union, the European Commission, has proposed a directive that would require EU member states to do the same. And we saw a colorful example of that in action when a Russian oligarch, Kerimov, sailed on his yacht into the sunset from the US. Basically, sorry, my lights have gone off. Lisa back. So he sailed off on his yacht out of the jurisdiction of the United States, and that yacht was seized pursuant to a mutual legal assistance request off the coast of Fiji and transferred back to the US. Why did that happen? Well, because sanctions evasion is a crime. That property was implicated in sanctions evasion, and therefore under US law can be confiscated, and Fiji gave effect to the mutual legal assistance request by the US. So that's the second approach, but it only catches the impatient people, the people who decide that instead of challenging sanctions in courts, they're going to try and take their property out of the jurisdiction. So some of them do that, but not all of them. And then finally, the third approach is what Tatiana spoke to in connection with Canada, where states say, well, actually, maybe we just take away the property that is subject to sanctions. And maybe there are some additional hurdles that need to be satisfied, or maybe not. My understanding of the Canadian legislation is that it doesn't really take much more to seize property compared to the initial freezing. So basically, if you're unlucky enough to be sanctioned, then I think under Canadian legislation, you've got pretty strong chances of actually having confiscation proceedings launched against your property, or at least that's a possibility. So I think that's broadly the current landscape.
Thank you very much. So my understanding of Canadian legislation is actually more or less the same, but I understand that it applies only to those sanctions, individuals and entity sanction in relation to the war in Ukraine. But it's quite interesting. So Canada was the first state to pass the law allowing confiscation of private wells, and that was done with quite interesting explanation related to human rights violation, etc., etc. So. But still, Tatiana has already started describing a bit the proceedings, how the confiscation works. But I think our audience would be interested in the details. So who could initiate, how this all happens, and what should be done, what is the standard of proof, where does money go, etc., etc. So a bit of details, if possible.
I'm not going to be able to talk to the Canadian approach. I can explain briefly how it would work in the UK. And,
okay.
I'll have a look quickly at what Canada has done, but I could explain why the standard of proof is so high, at least when it comes to legislation here. So in the UK, we did in fact consider, together with the bill for confiscation of state assets, issuing a bill which had been drafted for confiscation of oligarch assets, and it would have been very similar to what's proposed in Canada, very heavy control by the courts, and only it would have had to be proved that that particular individual was personally involved in violation of Human Rights Act or some sort of international law. The reason for that is the high level of protection offered to private property, private individuals' assets under Article and Protocol 1 of the European Convention on Human Rights. So there is a state at any stage is able to confiscate individuals' assets. So there is no, there's nothing stopping you from doing that, and it does do so quite regularly. For various reasons. I mean, there was confiscation obviously during the war, but also at the moment we're building lots of new rail lines, and so there's a property, a whole part of London is now subject to this confiscation order, and people aren't able to sell their properties there because at some point they'll be confiscated and the government will have to pay some sort of compensation. But there is a law which says that you can confiscate properties, but it's got to be reasonable, proportionate, and you've got to pay fair compensation. And so in that sense, confiscation for the sake of confiscation and the need to pay compensation for that confiscation, it just makes no sense. And the only way in which you can have proper confiscation is if you prove that that particular individual has himself been involved in a serious breach of human rights law, because the protection in itself arises under the human rights law. So that's the level of protection. That's the reason for the level of protection. In the end, it was decided that this sort of legislation wasn't necessary and will be too cumbersome in the UK. And that is because we already have unexplained wealth orders, for instance, which deal where assets. So who initiates it? It's got to be initiated by a government body which is responsible for implementing the particular legislation. So it would have been probably the office. I can't remember now what it stands for, the office which implements the sanctions here in the UK. So they would have to be initiating that. The problem is the funding. I mean, at the moment, the biggest issue we have in the UK is not the strength of sanctions. The sanctions that we have are pretty strong, but there is no enforcement. So you would need to spend a lot of government money on strengthening enforcement, because as Anton said, there's already ways of confiscating assets if you enforce it. So, for example, if you evade sanctions, that in itself is a criminal offence, and that allows you, under a separate act, Proceeds of Crime Act, there is legislation already in place which allows confiscation of assets which are tainted as proceeds of crime. So what has happened is that the UK has introduced a new offence in the Economic Crimes Bill of not disclosing your assets. So where you're a sanctioned individual and you fail to disclose all the assets that are subject to sanctions, that in itself becomes an offence, and therefore all of those assets you fail to disclose, and as I understand it, possibly all the other assets that are already frozen become subject to confiscation under the Proceeds of Crime Act. And there, of course, you don't have the issue of having to prove that you're confiscating because that individual has been involved in breach of the human rights law, or severe breach of the human rights law. So there are already all these mechanisms available for confiscation of private individuals' assets, but they're not being used because enforcement is not being funded. And I think that is the biggest issue facing the UK right now, and the biggest criticism is that whilst our sanctions legislation against individuals is quite strong, perhaps the most invasive within Europe at least, it is not being enforced, and therefore we simply do not know how much sanction evasion there is going on. So I know that there are reports that are being made about sanctions evasion, and I don't know what happens to those reports, whether they get investigated. There's certainly been no enforcement. The reason for that, and I think there needs to be another amendment, is that the government in particular is worried about the cost of enforcement, because people like Abramovich, for instance, have huge resources to defend themselves in courts. And this is why unexplained wealth orders are not used. They've been used 4 times. That's it. Since the legislation was introduced, I think for 8 years. And the reason is that it costs so much to go to court to defend that decision, but the government simply doesn't do it. And so what we need is some sort of cost protection regime for the government to ensure that there is a, let's say, a cost cap. So whatever, even if the government loses in court, the only obligation is to pay the other side's costs. So this is what happens at a court level. If you lose, we have a rule that says costs follow the event, which is similar in arbitration. So if you lose, you have to pay the other side's costs. So if the government loses, not only does it have to pay its lawyers, which are pretty cheap, because when you work for the government, you work at very low rates of those set. I do that, and so that's what you have to do. But the other side is not bound to instruct cheap lawyers, and people like Abramovich will instruct the most expensive lawyers, and then the government will have to pay his costs as well. And that's the biggest prevention of enforcement, to my mind. And so we've got to, again, help the government to start enforcing those breaches. So before we go even further, introduce more legislation, I think we have to start using effectively legislation that we do have.
Thank you, Tatiana. Oh, sorry.
Just to where does the money normally go? Normally, when the government enforces Proceeds of Crime Act, it goes to the Treasury, and so it becomes part of our budget. But of course, nothing is stopping the government from saying, okay, well, where we enforce against individual sanctions under the Russia sanctions, we will pass that money over either to Ukraine or to some central fund that's going to be formed for operations or anywhere else.
Thank you, Tatiana. Anton, would you like to add anything to the topic?
I definitely agree with the sentiment. I'm also somewhat wary of pushing the legislative envelope farther and farther. And fundamentally, look, we've got, as Tatiana said, we've got, most nations concerned here have got regimes to confiscate the proceeds of crime. And now they've got regimes in place to confiscate property that is involved in sanctions evasion. And if we go beyond that, we run into very serious rule of law concerns. I mean, why should we confiscate property that doesn't come from crime, is not implicated in sanctions evasion? It is a bit of a slippery slope. And I think here we're seeing a genuine dilemma of the kind that simply doesn't arise in the context of Russian state-owned property. There we've got assets that directly belong to the state that bears international responsibility vis-a-vis Ukraine and has that obligation to compensate. With the private property, the situation is much more complicated. And so, yeah, I definitely would endorse the call for more effective enforcement of the current laws. And the other side to this question is, what is the real policy argument in favor of pushing the envelope farther and farther? Why? At the end of the day, the amounts here are paltry compared to state-owned property. Okay, they're not insignificant. We are still talking about $60 billion worth of property, but it's scattered around multiple countries. It's in assets that might be difficult to manage, difficult to sell. All those yachts that might or might not be liquid assets. And so once you multiply those practical challenges and the fact that it's simply not the best source of property for rebuilding Ukraine, once you multiply that by very real and serious human rights and rule of law concerns, then I think that means that probably in terms of further legislative development, the state-owned assets present a much, much more important focus for our attention than the property of private individuals. Now, the other point I wanted to make very quickly is just to look at the Canadian legislation that you, Elena, have referred to. And I'm just looking at the provision that sets out the procedure for forfeiture of property that has been frozen under sanctions. And that provision says that the property that is the subject of the application can be forfeited to Her Majesty, and that would be His Majesty, in right of Canada, if the judge determines, based on the evidence presented, that the property is described in an order made under another paragraph in the regulations, which basically is saying, provided that the property is subject to sanctions, so that's the first condition. And then the second condition is that that property is owned by the person referred to in that order. So that's to say, is owned by a sanctioned person, or is held or controlled directly or indirectly by that person. In other words, what it seems to be saying to me is that as long as the property has already been frozen under sanctions, and as long as it's still owned, held, or controlled directly or indirectly by a person subject to sanctions, that property can be confiscated, can be forfeited. Now, whether or not that would fly in a country bound by the European Convention on Human Rights, I think is open to debate. Generally speaking, my understanding is that the European Court of Human Rights has been quite understanding of measures of states that have pursued a genuine public interest, anti-mafia measures against corrupt officials in Georgia, and a couple of situations like that. But even that does not obviate the broader policy question of, is that the right thing to do? How far should states go in terms of being quite so intrusive? So the Canadian example is really going to be this proverbial canary in the coal mine, where we'll see what happens to it, and then that will, I think, be quite interesting for other governments to observe.
I just wanted to, Elena, if I may jump on this topic as well. It's interesting to compare it with the regimes that currently exist in Ukraine. Because following the invasion, Ukraine developed its sanctions legislation and also provided a procedure for actually seizing the assets that were frozen in connection with Russian-related sanctions. However, unlike the Canadian approach, the Ukrainian approach provides for some additional criteria. So it is not enough that you're in the sanctions list. You also have to be somehow connected with Russian aggression against Ukraine, either financing it or directly participating in it, or participating in some sort of governmental or quasi-governmental administrative functions, and so on and so forth. And I guess the court procedure is a little bit more rigorous under the Ukrainian approach. And I guess that, Anton, you're right here that the scrutiny of the European Court of Human Rights might have been the main reason why Ukraine opted for this option, with when you can confiscate perhaps less because you have to prove that the person is directly related to the invasion. But the risk that this would not fly before the European Court of Human Rights is somewhat smaller as well. So it's just interesting to compare these two approaches. But is my understanding correct that so far Canada, aside from the Ukrainian regime, so far Canada is the only state that allows to confiscate just because you're on sanctions list?
I think that's right as far as I know. There's an interesting wrinkle to that, which is that the EU has had some history of freezing assets with a view to their ultimate confiscation, which is known as misappropriation sanctions, that were adopted around 2014, 2012, 2014, in response to revolutions in Egypt, Tunisia, and then indeed Ukraine, when the idea behind those sanctions was that assets would be temporarily frozen across the EU that allegedly belonged to corrupt former officials, and then the due process of law would run its course in the third country concerned, for example, Ukraine, and then once the final confiscation order is in place, that could be enforced in the EU. So that's sort of a similar, I suppose, policy precept where the EU adopted those measures specifically to facilitate confiscation, those freezing measures, but it didn't allow the confiscation of property simply on the basis of those people being sanctioned. They were waiting for criminal prosecutions or at least non-conviction based confiscation in those people's home country. So I think in the experience of the EU, that's the closest that we've seen so far to that notion of moving from freeze to seize in relation to private assets.
Thank you. I would like also to add that in my understanding, the philosophy of the Canadian law is that, so it's based on the grounds for confiscation is human law violation, and actually the disasters in Ukraine caused by the war, and first of all for Ukrainian people. And it's quite interesting that it's not only the ground, but the purpose of using those funds is also to somehow restore the those rights violated by Russia. And if you look at the purposes, a list of purposes for using those monies is actually about human rights, first of all, and restoring those rights to. And I think that is different from in Canadian case. I agree with Anton that indeed working with the issue of confiscation of private wealth is more practically is more difficult, more challenging, etc. But so far this part has moved a bit faster, at least with Canada. And in any case, there is an issue of sanction evasion, yeah, and that, even if it's practically more difficult, that is a policy issue. Because if you have sanctions as a tool, you need to ensure as a state or as European Union, you need to ensure that those sanctions are complied with. Otherwise, that would not be indeed efficient as a tool for any future purposes. So, Anton, you have already mentioned some US examples. And if you could briefly also cover how this confiscation for sanction evasion works in different jurisdictions, and against who commences the procedure, what is the standard of proof, where does the money go, etc. Because we understand that there are some developments in different jurisdictions in this regard as well.
Absolutely. My understanding is that by and large, confiscation in connection with sanctions evasion happens based on the application of ordinary proceeds of crime laws. For example, in the UK, as Tatiana mentioned, that would be the Proceeds of Crime Act 2002. In the US, that would be the respective US provisions. And so on. I think the situation would be probably the same in Australia. And so the idea is pretty straightforward. You've got sanctions evasion, and the property that is involved in that sanctions evasion is treated as proceeds of crime. Now, it might be a bit counterintuitive when you think about that from first principles, because if I engaged in drug trafficking, then I would be making money. That's my proceeds of crime. If someone sanctions me and I hide my property, I'm not really getting anything. I'm just, hiding my property. Is that really proceeds of crime? But I think the answer in the legislation, or at least in the case law of most states that have confronted that, is yes, it's still proceeds of crime. And even if not, that would still be apt to be covered by the notion of instruments of crime, so property that is involved in the commission of a criminal offense. So you've got property that is either the proceeds of crime or involved in the commission of a criminal offense. And then you've got fundamentally two different modes of confiscation. One would be confiscation that is predicated on a criminal conviction, where it follows from the conviction. Or the alternative would be what is known as non-conviction based asset forfeiture, or in the UK, civil recovery. And that is confiscation of property that is the proceeds of crime without a criminal conviction. And it's based on something that's a bit of a legal fiction, this notion that we're not accusing you of a crime, we're just saying that the property is derived from a crime. And by the way, you have committed that crime, but we're not accusing you of it. So there's not going to be a criminal trial. We don't need to give you the benefit of the whole suite of protections that attach to a criminal trial. Originally, when those procedures were introduced in a bunch of countries, they were intensely controversial because of the obvious concerns they raise in terms of the presumption of innocence. But over time, everyone's gotten used to them. They are a fixture of the legal landscape in pretty much everywhere where those laws have been introduced. And so this is the basis upon which property involved in sanctions evasion is being confiscated.
Thank you very much. And my last question is on a related topic, because a part of the sanctions evasion, there is also an issue of hiding assets in offshore jurisdiction. And probably that happened even before the sanctions were introduced. And sometimes it is difficult to trace because the sanctions entities and individuals are using different tools to do that. So what are the future trends and developments to tackle with that? And as I understand, there are some developments in the UK, Tatiana, in this regard. Could you please comment on that?
There are. I agree with you. We do know that a lot of the jurisdictions in the UK, such as Jersey and Guernsey, have been used as safe havens. There is currently a case going on about the Roman Abramovich's assets, which have been used to Guernsey or Jersey. I can't now recall which one, but so there is a case going on there where, on behalf of Roman Abramovich, the argument is that he was in fact invited by the government or by the governor of that particular island to put his assets there. And so effectively, the argument goes that by that invitation, the safety of his assets were guaranteed, and they should not be now subject to any sort of seizure and confiscation. As I understand it, there is a lot of work that goes on currently between the government of the UK and the governors of those safe haven jurisdictions to understand what can be done to allow for seizure and confiscation of assets which were moved in, as a workaround, in breach or as an evasion of sanctions, so to speak. And at which point, so the argument would be a legal argument as to at which point does it become an evasion of sanctions, an evasion of current legislative regime to move your assets out of England and into a safe haven such as Jersey or Guernsey or the Isle of Man. I would mention you, Elena, you asked about the proof, the standard proof, and it'll be just a simple balance of probability standard, so it will not. This is an interesting question. When it comes to the Proceeds of Crime Act, then I would say you probably be looking at beyond reasonable doubt. But
it's still the balance of probabilities if it's civil forfeiture, civil recovery.
Well, if it's civil recovery, yes, but at the moment, because the recoveries on the poker are actually done in criminal courts. And so criminal courts, and this is a big issue right now in the UK, whether criminal courts should in fact be looking at it, or whether it should all come to the Chancery Division of a civil court. And there's a lot of arguments to suggest that actually Chancery judges are much better placed to deal with complicated issue of assets and what exactly constitutes the proceeds of crime, because you're effectively tracing into certain assets. So at the moment, if some of the money you earn through sort of unlawful means can be traced into a house, and the house, for example, the house costs £1,000. This is just as an example, and you put 20 of that, £20 of that £1,000 sum is proceeds of crime. Well, in fact, the entire house can be confiscated. So that's how it works. But I believe that the proof that proceeds of crime were used will have to be on the criminal standard, beyond reasonable doubt, if it's under the poker. But this is actually an interesting issue, because if it's done, so in Canada, for example, under STEMA, that would be a balance of probabilities. So proof there would be on the balance of probability standard. And as Elena said, that's in fact the only legislation which specifically permits the proceeds, and then dates. I think the proceeds could be used only for the purposes of reconstruction of a foreign state, restoration of peace and security, and compensation of victims of grave breach of international peace and security. So, and that's the only legislation of its kind which allows you to do that, and the standard of proof is much lower. So the point is that if we do have new legislation to permit confiscation, it will not be a criminal standard that would be applicable to the balance of probabilities. Whether or not in practice it will make a difference, I'm not so sure, but it might do.
Thank you, Tatiana. Anton, any final comments?
Yeah, look, just to add quickly on sanctions enforcement, it's such a difficult challenge because, as I said, what banks are confronted with, and banks are basically the people who deal with money, right? This is where deposits would be held. So this is an essential front line of sanctions enforcement. And so they have lists that comprise many thousands of names that are pushed out by governments, and then they need to freeze the assets of people concerned. How do you know if a company that you deal with is controlled by a sanctioned individual? And this is where domestic governments need to step in and provide some pointers and engage with the private sector and tell them what they should be looking for. What are red flags? What does a Russian oligarch who holds his bank account indirectly in the name of his, driver or lover, what does that look like? How can banks try and identify that indirect exposure to sanctioned individuals? And I think so far, states in the EU in particular have had a very different track record of dealing with sanctions enforcement. Around, I think, a year ago, we saw some publications in the press that purported to leak confidential reporting from states to the European Commission on the amounts of assets that were frozen. Now, of course, we don't know for sure that that is those are genuine documents. But if we were to believe them, then the amounts range from dozens of billions in, for example, France or Belgium to, for example, Hungary, that said, we're so embarrassed by how little we froze that we're not going to tell you. And so I think that really demonstrates some of the issues around sanctions enforcement. And this is why the EU has announced its plans to create a centralized sanctions enforcement office at the union level, which would basically be the European counterpart of the OFSI in the UK and OFAC in the US. So we're seeing the Europeans kind of waking up to the reality of sanctions enforcement and saying, okay, now that we've got a serious sanction regime in place, we can't just keep pushing out those lists and hope for magic to happen. We actually need to engage very, very proactively with the private sector.
Thank
Yes.
you, Anton. Alexei, yeah, any comments?
Thank you, Anton. Yeah, I have no comments. I would like just to make a brief summary of what we have discussed, just to wrap up our discussion, because it was very interesting, and I guess it helped me personally to structure all the developments and divide them clearly in my head, what concerns what. So with respect to sovereign assets, it is really nice to hear from Anton regarding his view on two potential ways how confiscating may be in accordance with international law. We understand that the field is quite complicated, but both the option of countermeasures, especially with Anton's view on their reversibility, and the confiscation through executive action, as described also by Tatiana. Both options look like a way forward, which would be in accordance with international law if European, G7 and other states have enough political will to implement it. And the second key takeaway for me was to see how the legislation does develop and progress in parliaments of different states, albeit not strongly supported by the central governments now. But still, especially with the most recent American bill, it is very nice to see that some of the MPs and Ukraine are aligned in their vision how and where the assets of the Russian Federation should be transferred in terms of an international mechanism. And with respect to private assets, I guess also the most interesting part for me was that in most countries, the tools are there, both in terms of the proceeds of crime and sanction evasion. But as with everything, I guess, when it comes to implementing them in practice, we face many challenges. And it was very interesting to hear from Tatiana with respect to challenges that UK prosecuting authorities face with legal fees of the other party, and which exaggerate the risk of not being successful in a confiscation action. So it is really important that the practicalities of implementing these already existing tools are further reviewed and developed, both in terms of confiscating and just monitoring the efficiency of sanctions, which I guess in the countries we have discussed today, there is generally an understanding that this is what needs to be done, and certain moves in that direction, which is very good and very encouraging. And I guess another good key takeaway from me that we can all meet up in 3 or 4, 6 months and see how the situation develops, because it is very dynamic, and I guess we'll have much things to discuss by then. And I would like once again to thank you very much, Anton and Tatiana, for finding time to join and share your interesting ideas with us. And of course, thank you to Elena for co-moderating this.
And thank you for our audience to be with us today. Thank you very much. Have a nice day.
Thank you.
Thanks so much.
Bye.